the applicability of Chapter 82 of the Texas Property Code, which does not apply in this particular situation, just based on the date that this condominium association was founded. So it would be Chapter 81 that would apply in large part to this association. Leading up to this hearing, there was a response filed by the plaintiff to our motion to dismiss, and there was also an amended petition filed. The response actually simply incorporated the amended petition and urged that because of the amended petition, our 91A motion would be rendered moot. However, these filings were made on Friday of last week. And so we have since then, and I don't think the clerk would have accepted this at this time, but we have moved to strike those filings as untimely. The reason for that is pursuant to Rule 91A, in Part 4, any response would have to have been filed 7 days before this hearing, so last Monday, and any amended pleading or non-suit would have had to have been filed 3 business days essentially before this hearing. But all of these things were filed on Friday, and so we're moving to strike those filings of January 21st, 2022 as untimely. And so that's kind of a threshold issue to all the arguments maybe that we're facing here.
All right, so under 91A point, and I'm unfortunately, my book is a couple years old, so I don't think this has changed, but 91A.5, subsection B, it says if the respondent amends the challenge cause of action at least 3 days before the hearing, the movement may, before the date of the hearing, follow a withdrawal of the motion or an amended motion directed to the amended cause of action.
Yes, Your Honor, that's the provision we're relying on. And of course, in combination with Rule 4, that 3-day period would not include Saturdays or Sundays in this situation. So it would have been due last Wednesday, but it was early on the 21st that we received them. And so we're moving to strike them as untimely. And it's our position that pursuant to that same rule that Your Honor was just citing, the court actually must not consider any amended pleadings filed not pursuant to the rule.
So Rule 4 says at the end, the last day of the period so computed is to be included unless it is a Saturday, Sunday, or legal holiday, which event the period runs until the end of the next day, which is not a Saturday, Sunday, or legal holiday. And legal holidays should be counted for the purpose of the 3-day periods in Rule 20 and 21A, extending other periods by 3 days when service is by mail. Okay, so I guess your argument that doesn't apply, I don't think. So that Rule 4 says it should have been at least 3 days, not counting Saturday and Sunday. Ms. Curtis, what is your response?
Well, Your Honor, our response would be that plaintiff is entitled to amend her petition at any time. And we're happy to go forward with the hearing today based on whatever it is defendant thinks needs to be challenged. But the amended petition is currently live before the court, Your Honor. However, defendant's motion to strike is not properly before the court. The amended petition can't be struck like an ordinary motion or a response, and we're happy to move forward. Our response is that, the pleadings as they stand have now been altered. We have to go forward. Now, I will point out to the court that the plaintiff's counsel called defendant's counsel on Friday, not only to confirm receipt of the amended petition, but also to offer to extend and move this hearing, Your Honor, to give everyone time to respond appropriately, and defendant's counsel declined. We're happy to go forward with the rest of the argument, but I think this is plaintiff's motion, Your Honor, so we'll proceed as you see fit.
You mean defendant's motion?
Yes, Your Honor.
It's okay.
May I have a moment to briefly respond to those points?
Sure.
We would just argue, of course, Your Honor, the plaintiff can amend their petition at any time. The problem here is that the court doesn't have, unfortunately, the discretion to consider the amended pleadings for purposes of this particular hearing, as set out in Rule 91A.5 Part C. And so to the extent the motion to strike that we have filed that would be before the court is not the right procedural mechanism, the point that we're trying to make is that for purposes of this motion to dismiss, unfortunately, the court can't consider the amended pleadings filed last Friday. And I did confer with opposing counsel, and as I informed opposing counsel, I hadn't had a chance to review anything that was filed, as it had just been filed very early that morning, but I would look at it and I would inform the other side of what I was doing, which is what I did. And and I would do whatever I needed to advocate on behalf of my client fully today. So we don't think that we can move this hearing as a result of those untimely filings, just because of the 60-day provision within Rule 91A. The court should rule within 60 days of our filing, and we're approaching that here. It's been almost 60 days
So,
now.
Ms. Cherry, let me ask you a couple quick questions here. One is, let's assume that, first off, my recollection is, but unfortunately I realize I don't have a current rule book, the statute that provides the underpinning for Rule 91A was amended, I think, in the last legislative session, or maybe it was the session before, to make the award of attorney's fees discretionary with the judge. Is that correct?
That's my understanding, yes, Your Honor.
And with that, I don't know what the operative date that went into effect, because I see very few of these 91A motions. Is it discretionary in this case whether or not the court awards attorney's fees?
If Your Honor is asking whether it's discretionary or mandatory, yes, with a TCPA motion.
Right.
Yes, in this case, my understanding is that it's discretionary.
And so I guess my next question is, let's assume that it was timely filed. Do you have any objection to the amended pleadings? Is it still defective according to you?
Yes, Your Honor, it is. It doesn't address the situation before the court today, primarily because it incorporates plaintiff's original petition. And so the problematic pleading that we are complaining of is still live. So regardless of whether the court considers—
What do you mean it incorporates the original petition?
The amended petition filed last Friday by the plaintiff states that it explicitly it is incorporating plaintiff's original petition.
Well, then it would be a supplement, not an amendment, right?
So essentially, I suppose that's the intent. So none of the arguments made in plaintiff's motion to dismiss would be resolved, whether the court considers the amended pleadings or not. But I would urge the court that the one item within the rule that the court doesn't have much discretion over, any discretion over in this case, is whether or not it may consider the amended pleading today. And our position is that the court unfortunately can't consider the amended pleading at all.
Your Honor, may I respond?
Sure.
So because we're discussing timelines, 91A3 requires, and I think Ms. Cherry touched on this, that the 91A be granted or denied within 45 days of filing. It is 45 days, not 60 days. This motion was filed on November 29th, Your Honor. 45 days after that is on or about January 13th, 2022, which it was a Thursday. It didn't fall on a holiday or Saturday or Sunday. We are currently on January 24th, Your Honor. So this motion should have been heard on or before the 13th. all the courtesies that plaintiff's counsel has extended defendant's counsel, were obviously unnecessary. This motion should have been heard already, Your Honor, and it hasn't. I'm not sure what the consequence of failing to hear the motion on or before the 45th day
I think
would be.
isn't it denied by as a matter
Operation of law. Yes, I think so, Your Honor.
If I may, Your Honor, and I didn't foresee this argument, so I don't have the case law in front of me, but I'm very confident that the case law interpreting Rule 91A, even in providing the timeline in which the court shall rule, that has been perceived as the court may rule later than that, particularly if there's no hearing within that time frame. And I'm happy to brief the court on that. I've seen a lot of case law interpreting the time frame in which the court has to rule on a 91A motion, and the court does have discretion there. Even despite the shall language or must language in the rule. And so I believe the court may rule on this motion, but at its earliest, availability. And this was the first time that we could get a hearing before the court on this motion, which was timely filed.
So let me just kind of let you know kind of where I'm heading with all this, which is, I am not a huge fan of 91A, especially the attorney's fees provision. So what I in any case that I can, unless I just feel that there's been a real abuse, which I don't feel that there has been in this case, at least not yet. I'm gonna, if I have discretion, I'm probably not going to award attorney's fees. So that being said, there's an amended, both of you guys kind of have missed your deadlines. One of maybe a discretionary miss. The other one may not be. I'm not 100% sure. I am kind of familiar with the case law that Ms. Cherry's talking about, but it hasn't been briefed. Which is kind of why I was getting at this amended petition issue is, if the amended petition deals with the issues raised in the motion to dismiss, then kind of no harm, no foul, in my opinion. But
Certainly. Our position is it does not deal with any of the issues in the motion to dismiss.
Your Honor, I can speak to that to save you a little reading, Your Honor.
Sure, go ahead.
Okay. It's plaintiff's understanding that most of defendants' claims are couched in the applicability of Chapter 82 of the Property Code versus Chapter 81 of the Property Code. I do think that there was some substantive issues there that have since been addressed, but ultimately there are many questions of law as far as which of the property codes applies, how, when, and to what provisions. But to answer at a minimum, defendant's breach of fiduciary duty claim previously couched in Chapter 82 is now couched in the bylaws and an express fiduciary duty required of defendants. The negligence per se claim, I think, is still the one at most issue, and the applicability of the statutes there, which has also been changed. The statutes that apply have been changed in plaintiff's amended petition. And then there was an argument, I believe, by defendants for the piercing of the corporate veil. That has also been addressed in that different provisions apply. The bylaws, the declaration of defendants, defendant Bent-Tree's bylaw and declarations do have some specific provisions in there that require or do not require certain things, or prevent indemnification of the officers, directors of defendant Bent-Tree, such that the corporate veil should be pierced for some of the misconduct, the bad faith action.
So Ms. Curtis, if I understand what you're saying, and I don't want to misspeak, is that you're saying that the breach of fiduciary duty claims and the negligent per se claims, you agree that they were not filed under the correct provision of the property code. And since then, you've amended it to include what you believe is the correct version of the property code. Is that correct?
Your Honor, I believe the breach of fiduciary duty claim, which was couched in the property code, was properly corrected and has been changed as such. The negligence per se claim still discusses an issue of the property code, a different section of the code, and I think it's going to be a similar argument that that section of the code doesn't apply. But yes, Your Honor, I believe they have been appropriately changed, not only to improve plaintiff's arguments, but also to address defendant's motion to dismiss.
If I may, Your Honor, I have a brief response to that.
Okay.
And again, this amended filing was just me last Friday, so I have had a chance to review, but not to the extent that I would want to and research accordingly. But my understanding of the amended petition, which again, the court, for purposes of today, we believe the court cannot unfortunately consider, doesn't cite to a different provision of the Texas property code to resolve the issues that we complain of. It argues that that Chapter 82 does apply based on an exception within that statute, and we disagree. And so it still relies on all the same arguments, but argues that a provision within Chapter 82 that creates an exception for the older condominium associations applies here. And I don't see how that's the case. I can elaborate on that a little bit if the court would like.
I mean, what I'm inclined to do, I guess, is to grant the motion to dismiss, partial motion to dismiss, dismissing the claims in the original petition without prejudice to allowing the plaintiffs to amend, which I would allow, and then denying any attorney's fees in this case. And so it's clear that whatever's been pled would be dismissed, and then, but it doesn't prevent the plaintiff from amending the petition and adding these additional, or these claims based on additional provisions. I guess that's kind of where I'm going with this. So, Ms. Curtis, why don't you prepare an order that so states, share it with Ms. Cherry. Make sure at the beginning of the order it says that this was heard on January 24th, 2022. Make sure that you email Rhonda, my court coordinator, as well as e-filing this order. Preferably you'd get Ms. Cherry sign off. Ms. Cherry, you have up to 24 hours to sign off on the order. Anything else, guys?
Thank you, Your Honor.
Thank you, Your Honor.
Good luck, guys.
May we
great
be
day.
excused?
You are excused. Good to see you.
Thank you.
Thank you.
All right, is everyone here for the next hearing?
If the next hearing is Solomon and Patriotic, sir, I'm here for that, but we're 7 minutes ahead of time.
Yeah, it's if everyone's not here, it's no big deal. We can start early if we.
Mr. Whitfield's here, so I think we have everybody we need.
I saw a scheduling conference right ahead of us, Your Honor.
Oh, are we jumping somebody? Sorry.
Looks like it.
No, that's already been resolved.
Okay.
Okay, everyone's here in HSB, Solomon Associates versus Patriotic Energies and Technologies. Is that correct?
Yes, Your Honor.
Tony, you ready to go on the record?
Yes, Judge.
Let's go on the record on DC 216593, HSB Solomon Associates LLC versus Patriotic Energies and Technologies Company Limited. Counsel, make your appearances.
Thank you, sir. Daniel Shrest for the plaintiff, Solomon.
Morning, Your Honor. Jeff Whitfield for the defendants, Patriotic, and the Oil Field Workers Trade Union.
Oh, yes, I remember this. This is a very interesting argument here. Okay. I've read all the briefing. Is there a Mr. Cartwright who's involved in this case too?
Not for the
Not that I'm
one.
aware of, Your Honor.
Okay. You may proceed.
Your Honor, clearly you've seen our briefing. I'll try to streamline this. I mean, our position on the argument here is that the relationship between Patriotic, OWTU, and Solomon could not have existed but for the confidentiality agreement. On
How
February
do you
the 9th,
deal though with the issue of the merger clause? I mean, that to me kind of disposes of this whole thing, unless there's some very strong argument to the contrary. There was a merger clause, I guess, and I can forget the name of the subsequent contract that basically said this is the full and final agreement. Wouldn't that get rid of the confidentiality agreement, or is there some case law to the contrary?
Your Honor, the Deepwater Cylinder Wells case out of the Houston 14th Court of Appeals and other cases, but that one's so directly on point, summarizes this exact situation. You had an initial agreement between two parties, one a consulting relationship, and as part of that initial agreement, the parties said that they were going to have a mandatory form selection. Later, they have a confidentiality agreement that doesn't contain a mandatory form selection, but it contains a merger clause. And so what the court, and as other courts, but let's talk specifically about this case, what the court says is that for there to be a merger, first, you have to look at the documents to see if these two agreements must be read together. It's very clear that these two agreements have to be read together. You cannot have the consulting agreement. You'd have absurd results without the confidentiality agreement surviving, because Solomon, its only obligation to maintain confidentiality of the Patriotic information is in that initial agreement. The later agreement says that Patriotic has to preserve the confidentiality of Solomon's information. So those two agreements have to be read together. And it's very clear that even in the confidentiality agreement, it says that the consideration for the confidentiality is going to be the funds that are paid as part of the consulting agreement. That consideration for the earlier agreement is the money to be paid for the later agreement. So when you look at the two agreements,
do you have a copy of this Deepwater case? It discusses a choice of venue clause, I guess, that was in the original contract, and it survived to the second contract, even though there's a merger clause?
yes, Your Honor, we do.
All right, go ahead and share screen that. Are you familiar with this case, Mr. Sherrist?
Yeah, we talk about it in our brief, sir. It doesn't bother us at all. We'll talk about it when I have a turn. Should say yes, not yeah. Sorry.
What did you say?
Should say yes, not yeah. I was too. I apologize.
We're real casual here in the 68. Don't worry about it. I just don't like the word ain't. Just don't use that one, okay?
I ain't planning to.
All right, Your Honor. So let's go down to, in fact, I'm going to pull up the head note here. So really, I'm going to start from Westlaw here.
Okay.
So head note 8 summarizes the position here. Even if confidentiality agreement between consultants and client company took effect after the parties' consulting agreement. So in this case, it's a reverse format. So you had the initial agreement was the consulting agreement. The later agreement is the confidentiality agreement. But it says even if the confidentiality agreement took effect after the parties' consulting agreement, the merger clause did not supersede the form selection clause in the consulting agreement, even though the merger clause indicated that the confidentiality agreement contained the parties' entire agreement with respect to the subject matter. And
Wait, so in this, am I reading this correctly? Is in this case, the confidentiality agreement had the merger clause, and so and that would say that any prior agreement to the confidentiality, which was entered into first, any prior agreements were merged into the confidentiality agreement.
So
I mean, that's completely opposite of what we have here, it appears.
actually the other way around, the consulting agreement, let's see, the merger clause and the confidentiality agreement. So you have the merger clause in the later agreement did not supersede the form selection clause in the earlier agreement. So the earlier agreement, which was the consulting agreement, had a form selection clause. The later agreement, which was the confidentiality agreement, had a merger provision. But what the court finds is, because there's only one forum selection provision in one of those two agreements, and it's in that earlier agreement. The later agreement doesn't have form selection language. And the court says, well, they didn't get rid of their form selection because they don't have a different statement in this later agreement. And you have to look at the two of them together. The confidentiality and the consulting agreement have to be read together. You can't merge out unless there is conflicting language. You'll see this portion here. Enforcement of the form selection clause did not conflict with the terms of the confidentiality agreement. So that's the situation we have here, Your Honor, is that if you get rid of, if the later agreement, so, and I should also give context, there are actually two consulting agreements. There's a later consulting agreement in 2020, and then there was a consulting agreement in March of 2019, less than 1 month after the confidentiality agreement, which contained the form selection language. So of course, the merger in the 2020 agreement is saying we're doing away with everything from the 2019 consulting agreement, but we're not doing away with everything from the confidentiality agreement, because if you do, you get rid of Solomon's obligation to preserve confidential information that Patriotic provided to Solomon. And again, the provision, if I can pull up the very specific provision, I know the court has this, but just for convenience, let me bring up the actual agreement here. It's very broad. Trying to find that document, Your Honor, but I'm sure the court has it in front of it, and we briefed it extensively. When you look at what is being said in the confidentiality agreement, that original agreement, it says that each party irrevocably agrees that the courts of England and Wales shall have exclusive jurisdiction to settle any dispute or claim, including non-contractual disputes or claims, arising out of or in connection with this agreement, or its subject matter, or its formation. And as we cited the treatise that former Supreme Court Justice Enoch had put together, when parties use this exceedingly broad language, not only arising out of, but in connection with this agreement or its subject matter formation, you look at the confidentiality agreement and it says that Solomon is talking to Patriotic about confidential information it will be providing relating to the potential acquisition of this refinery. And that goes on to say that the consideration, part of the consideration here for that confidential information is the funds to be paid later. So first, to address your earlier point, the merger clause hasn't gotten rid of this confidentiality agreement because the later agreement doesn't specifically address these points. There is no conflict between these two documents. They have to be read together. And furthermore, since we do away with the merger, taking away that earlier agreement, the second question they pose is this: the first agreement they suggest is just solely about confidentiality. Confidentiality of what? Confidentiality of all the information Patriotic was going to provide Solomon pertaining to this acquisition, pertaining to the very thing they're now suing for recovery of funds. And again, the consideration for the confidentiality agreement is what they're suing over. They're saying that they weren't giving money. It raises issues of lack of consideration. It raises, I mean, if they get their way, then what was their consideration to us to pay them in the later point? So the merger agreement does not get rid of the form selection provision. And this dispute, because the parties chose to make the language very, very broad in the form selection provision, this dispute falls squarely within something. If this was an arbitration provision, which obviously a mandatory form selection is to be looked at as an arbitration provision, this should also be sent to arbitration. In this case, it should be sent to the courts of England or Wales to resolve this dispute.
Response?
Yeah, so the court is exactly right. I'll start with the Deepwater thing first, because the representation was that's the case that gets them out of the merger provision. The Deepwater case, the original contract was the consulting agreement, the larger, broader relationship. Attached to, appended to that agreement was a confidentiality agreement. In the first broader agreement, there was a form slushing clause. In the thing that was signed later, although it was attached to, referenced in the master agreement, that did not have a form slushing clause, and it has a merger provision. But all these merger provisions, you have to remember what the way they really work. As to the subject matter hereof, the thing is merged. Okay. And so the point there is, in this broader sort of, in this more narrow focus, even though the confidentiality agreement in Deepwater did not have its own form slushing clause, and though it had a merger, its merger was as to the subject matter of the confidentiality agreement, which is confidential information and the obligations there too. So to the extent the master agreement said anything about it, boom, it merges down on confidentiality issues there. But the court said, look, you have to read them together because they're attached, they refer to each other. That's the first distinction. Our situation is not that. Our situation is, it's like an NDA, basically, the confidentiality agreement. Hey, we might want to do business. We want to share some stuff with you. You can't tell anyone about it, and you have to hold this information confidential. And I don't know if you remember, I don't know if the court remembers the first, when we heard about this agreement the first time, was at the last motion for continuance. The first argument then was, oh, it says there, as to the subject matter thereof, and look, the matter is the acquisition of the refinery. Well, there was a shell game, because the term matter is defined, and it means like the business of like what we're planning to do, not the subject matter of the contract. The subject matter of the confidentiality agreement is absolutely confidential information, and the issues there too. If we were suing because, or being sued because of a breach of the confidentiality obligations, I would say we have to go to Wales. But we are suing because of a breach of the later merged provision agreement, that is the broader agreement, the consulting agreement. And that's why it's exactly, you're right, when the court was right, when in response to the argument, it's the exact opposite of Deepwater. In Deepwater, the broader provision had the form slushing clause, and the more narrow provision was appended to and referenced in it did not. And the court read those together because it was arising out of or relating to the broader agreement. This is the exact opposite, where the narrow agreement has the merger provision, the form slushing clause. The later agreement says, here's the new terms, here's what we're actually going to do, here's the consulting agreement. And by the way, on the merger provision, what it says is, to the extent anything in any prior agreement had to do with the subject matter of this agreement, which is consulting services, it is merged into this one. So again, if we have a fight about confidentiality, about the breach of Solomon's obligation under the confidentiality agreement, the merger provision probably would not affect that, because that is still outside of the subject matter of the consulting services agreement, and within the subject matter of the confidentiality agreement. But that is not the case here. And they're trying to draw, oh, there's consideration, it's mentioned, it's here. Yeah, it's contemplated that sometime later these things will happen, but then it did happen. A subsequent agreement was signed, and then a subsequent agreement to that was signed, all of which said whatever we talked about before with respect to the conveyance of consulting services, including non-payment, right, would be covered by this new agreement, and everything else is merged into it. And it's as simple as that. I mean, when we responded, we were playing a little bit of whack-a-mole with the different positions the defense was taking. So I wasn't sure if it was, are they arguing that the subject matters are the same, or are they different? So because if the subject matters are the same, the merger provision absolutely subsumes the confidentiality agreement. It's not exactly that. They say, and I think I agree, that the subject matters are different, meaning the subject matter of the confidentiality agreement is the obligations pertaining to confidentiality. The subject matter of the consulting services agreement, both the original and the subsequent one, are the provision of consulting services. And to the extent there is any overlap in that Venn diagram, the terms of the consulting services Yeah, that's right. The terms of the consulting services merge out anything related to that and put it into the consulting services agreement. That's how they work. So and that's the point of the merger is to say whatever else happened before, this is the document. And it's ironic, right? Because the only reason anyone thought about this document was because we produced it in connection with their personal jurisdiction argument when they pretended like they had no ties to Texas, when it talks about, look, you already had an agreement with us in Texas. And then all of a sudden they waved it around saying, oh, there's a form selection clause. I mean, it was an accident, okay? And the notion that they have to be read together, maybe if there was a fight about confidentiality, that would be an issue we have to deal with, but that is not the case here. We are suing under the consulting services agreement. The terms of the consulting services agreement stand alone by virtue of the merger. And to the extent anything else might have affected it, it's gone because of the merger provision. That's it.
Your Honor, if I can briefly reply.
Briefly.
Your Honor, Mr. Charest just made the point that we made in our reply, although a slight deviation here. We say exactly the same, that if there was a merger, it was a merger only of the subject matter, and the consulting agreement has a different subject matter, pertains to the consulting agreement terms versus the confidentiality agreement pertaining to confidentiality. But when you read both of them together, you can have no merger because there is not a direct conflict between the latter agreement and the former agreement. He would have to concede that the consulting agreements do not have any form selection language in them. There is no demand in the consulting agreements for form selection, but the parties said in their earlier agreement where form selection would be. And they chose to use broad language that catches anything arising from or in connection with the agreement.
Are there any, I guess my question, are there any cases that, I mean, I agree. I don't think this case is on point. It's definitely not mandatory for me to follow it, but are there any cases that have, an earlier broad form selection clause in an initial agreement, and then that supersedes a later agreement as to a merger? Because this has to come up, you know what I mean? This type of issue has to come up. So I would think that there'd be some cases on point.
We didn't find a case that was exactly on point, but all the cases we found where they saw broad language in an earlier agreement arising from, in connection with, related to, what the court said was, or what the various courts said was, when you have broad language, that means the parties are going to catch whatever dispute arises in connection with or related to the cause of action. Where, with regard to the cases on merger, and I'm looking through my notes to see the one. We feel like Deepwater is so directly in point. I'm stymied here that, because to me it is so clear that that these two have to be read together. But I don't have another case I can point you to other than to say I know that when it comes to the cases we've looked at, there wasn't a case that was exactly like this. But Deepwater is mighty close if you flip consulting and confidentiality, because bear in mind, in the Deepwater case, here's the other twist there. In Deepwater, here, plaintiffs are suing over the consulting agreement and the failure to pay, right? With the confidentiality agreement here having the form selection. In Deepwater, the plaintiffs were suing over breaches of confidentiality, but the consulting agreement had the form selection. So the plaintiffs there made the same argument. Oh, they're disconnected and not the same, and you can't read them together, and there's a merger clause. So in fact, the flip situation, it's not like you cannot have a consulting agreement here without a confidentiality agreement. Just like in the Deepwater case, you couldn't have confidentiality agreements without the consulting agreement. The two, it's just the order in which they appeared are flipped, but the relationship, they're critically connected each to one another in both our case and that case.
So, Mr. Sheriff, what is your best case kind of for your position?
I don't think we have cases saying that we're right because the documents say it. You know what I mean? We respond to their argument that you would need to read them together because the answer is you read things together when you need the broader context to understand the transaction, and here you don't because of the merger provision. That's the point of the merger provision. And defendant said it
Clearly,
earlier.
there's a lot of cases on merger provisions. So, I mean, are there any that have a situation where merger provision in one contract eliminates a form selection in another contract, an earlier contract, where there wasn't a form selection clause in the second contract?
Like the defendant, the movement here, I don't have a case on hand to answer that. What we do have is the movement not being able to prove that it works the way they want it to work. And this notion of the necessary relation between them is just lawyer talk. There's no evidence of that in the record. Okay, there's no actual, they submitted the same declaration that they submitted from the personal jurisdiction argument, but there's nothing about the necessary connection between the two. The very point of having a merger provision is so we know we only need to look at this one thing. And if that doesn't, if it's a lawsuit about the subject matter of the consulting services agreement, then everything else that was ever talked about relating to the purveying of the exchange of consulting services agreement for pay is in that document. Otherwise, we'd be going on and on forever. And you know, again, deep water is exactly the opposite, not exactly the same. Deep water is when the smaller, more narrow obligation comes out of the broader one that has the provision. And here, the broader relationship does not have the provision. It has, in fact, the opposite, the merger. And you have to assume that the parties, they know how to do a merger provision, or they know how to do a form selection clause, and they didn't. They had one in a prior agreement, and they didn't in a subsequent. They have a merger provision. You have to give effect to that. I mean, beyond that, I don't know what to say.
And Your Honor, my colleague pointed out, we did put a case in our reply. You'll have it in your file. It's the Polaris Guidance versus EOG Resources case, which may address the point that you've raised, or the question you've asked.
Well, if I may address Polaris, sir, it's not that the two agreements conflict, but rather whether or not the parties intended the earlier agreement to govern the second one. You know, and the parties entered into a master service agreement first. And a few weeks later, they entered into two more agreements, a licensing agreement and a quote, both of which are sort of derivative agreements. And the MSA says it's the same thing as deep water. The MSA says it shall control and govern all services provided, blah, 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 blah. And so it has the same sort of deal where the bigger, broader agreement has the thing they want. And then there's a fight about the smaller ancillary agreements. Again, it's exactly the opposite of our situation and exactly the same as deep water.
And Your Honor, you'll see in the reply, we lay it out. The key here is whether the agreements conflict. And that's what Polaris points out is when the later agreement provisions don't conflict with the earlier agreement and they're read together, you can't just say a merger agreement gets rid of everything. There has to be a conflict when the documents are being read together. So that's why we provide you Polaris in the reply.
Yeah. Because you have to look at the main provision, the main agreement to know how to deal with the smaller agreements. I mean, fundamentally, this notion of reading, I'm sorry, just a second.
Sorry,
the notion of reading agreements together is an interpretive tool when the document you have does not supply the answer. Here, the document works on its own, standing alone. There's no requirement to go to this next level anyway. It's an interpretive tool that's not called for here. There's no ambiguity to understand. And they didn't even realize it until we filed the motion, until they wanted to continue this. So, anyway.
All right, I'm going to go ahead and deny the motion to dismiss, and you submitted an order already, so I will go ahead and sign that order.
Thank you.
You guys have a great day and good briefing.